All right, peace and blessings. February 16th, Friday, 2018. Mike Parsons called me tonight. He had his wife send me an 11-page petition that he's written to Judge Lippman. Judge Lippman is the one that's ordered his wife to surrender. His wife's name, by the way, is Pat Parsons. She is a dear, sweet soul. His wife, assuming God doesn't work a mighty miracle, and we are certainly praying for that, will have to surrender herself on February the 20th to an Alabama prison for a 5-year prison sentence for a crime that she did not commit, and a satanic FBI entrapped her. And Mike wrote an 11-page petition. I've got it uploaded to Year of Jubilee. You can download it and read it yourself. But Mike asked me to read it, and because I respect Mike and I care about him, I care about Pat, I thought I would go ahead and read it. Mike asked me to give him my 2 cents. If I'm going to read it, I might as well read it into a recorder. And maybe if it does you some good, where you can have somebody read it to you, as opposed to reading it yourself, you can drive down the road and play it, whatever the case may be. But let's go ahead and read Mike Parsons' petition to Judge Lippman. This is for his wife, who's going to have to submit herself to an Alabama prison for a 5-year prison sentence on a crime she did not commit. Petitioner, by special appearance only, Ambassador Michael Wayne Parsons of the Tilshikotan Nation, country of the Tilshikotan, a live man under duress, without prejudice by right, common law, and commandment of Almighty God, on behalf of my wife, Patricia Parsons. 2. Honorable Judge Lippman, United States District Court, care of the Clerk of the U.S. District Court, 167 South Main Street, Memphis, Tennessee, 38103. Notice: demand as a matter of right, order to set aside and vacate this court's order sentencing Patricia Parsons to prison and order a stay of the report date specified by the U.S. Marshals on February 20th, 2018. Whereas the order sentencing Patricia Parsons is in violation of international law, the Vienna Convention on Diplomatic Relations on 18th of April 1961, entered into force on the 24th of April 1964, United Nations Treaty, Series Volume 500, page 95. The United States Constitution, Amendment 5, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of indictment of a grand jury deprived of life, liberty, or property without the due process of law. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to be informed of the nature and a cause of the accusation and to have the assistance of counsel for her defense. Amendment 8. Excessive bail shall not be received, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Amendment 9. Rights retained by the people, 28 U.S.C. 1330 and 28 U.S.C. 2255. 1. Ineffective assistance of counsel. 2. Prosecutorial misconduct. 3. Newly discovered evidence and entrapment by the FBI, and as such, the sentencing order shall be set aside, vacated, and a stay on the report date. History of the matter, facts, and foundation. 1. In the spring of 2017, it appears that the Court of Tilshikotan Nation, the Universal Supreme Court of the Tilshikotan, herein referred to as USCT, issued an order for petitioner's immediate release and a warrant for the arrest of a judge who falsely ordered petitioner's arrest for failure to appear in his court, despite there being no order directing petitioner to appear. The Tilshikotan is a sovereign First Nation in what you may consider British Columbia, Canada. However, the Tilshikotan Nation has never signed over the rights to their land and is recognized as an autonomous self-governing nation with the inherent rights recognized by the Montevideo Convention on Rights and Duties of States, including the right to define the jurisdiction of their courts. The USCT was created by an act of the Constitution of the Tilshikotan via the Tilshikotan Nation Congress, and the USCT was affirmed and its Chief Justice appointed by hereditary Queen Clan Mother Dorothy Boyd. See Universal Supreme Court Act, the Constitution of the Tilshikotan Nation at www.universalsupremecourt.org. 2. In 2015, I was adopted by the Tilshikotan, and on January the 1st, 2016, I was appointed the ambassador of the Tilshikotan Nation to the United States. My being detained has placed a tremendous burden on the Shilkotan, whereas I was facilitating negotiations between the Chillicothe Nation, a logging company in Tennessee, and an international buyer. The Chilcotin are in great need of jobs, and without this timber deal, many have lost their children to the Canadian foster care system. As one can imagine, they desperately want my release. 3. Therefore, when their court order for my release was ignored, they were advised to seek help from this country's law enforcement services to stop the ongoing interference in the Chillicothe Nation's internal affairs by the judge who legally ordered me being kidnapped and held hostage in violation of international law. Vienna Convention on Diplomatic Relations, April the 18th, 1961, United Nations Treaty Series, Volume 500, page 95. 4. Then, according to the FBI's own report, a licensed business operating in this country at the Fugitive Recovery and Transport Service was contacted by Justice Holland of the USCT. And according to the FBI's own report, the USCT order for my release and the USCT indictments and warrants for the arrest of those responsible for ordering me kidnapped and held hostage were issued to that Fugitive Recovery and Transport Company. Nowhere in the FBI report do they claim the USCT orders, indictments, or warrants are not valid or lawful. 5. The FBI's own report states it was their confidential human source, CHS, who contacted Ms. Parsons. Their report states Holland provided Ms. Parsons' phone number to CHS to call that number to reach Holland, that Holland discussed hiring the CHS to execute arrest warrants, to execute a USCT order releasing Michael Parsons from jail, and Holland negotiated a price to conduct the arrest operation and to free Michael Parsons from jail. That Holland transmitted a contract, that Holland transmitted the USCT indictments and USCT order to release Parsons from jail. 6. Ms. Parsons did not initiate contact with CHS, nor did she provide her number to Justice Holland to offer to others. Ms. Parsons never agreed to anything, was never part of any negotiations, and never asked anyone to take a car in lieu of $5,000. Ms. Parsons never consented to any monitoring or recording of her calls by the FBI, CHS, or any others with any agency. See affidavit of Patricia Parsons. 7. Ms. Parsons has nothing to do with the affairs of the USCT, but was hopeful the efforts to exercise the USCT order for my release would prevent me from being killed in the Tipton County Jail, where there had been 2 attempts on my life. The FBI interference that Ms. Parsons said that she did not want the FBI knocking on her door does not infer anything other than she will not be a party to anything illegal. Keep in mind that it's been recorded that Miss Pat Parsons said she doesn't want the FBI knocking on her door, and when she told the confidential human source that, in effect what she's saying is, I do not want to participate in anything illegal. Number 8. The FBI's own report references a phone call from me to Ms. Parsons discussing Holland's efforts to help Parsons. Patricia stated, she's having a hard time getting through. She thought she got closer to Trump. Parsons added, I've sent emails to Trump and I have scanned and sent things to both governors of Nebraska and Tennessee. Clearly, our reaching out to the leaders of those governments demonstrates efforts working peacefully within the lawful channels for diplomatic relations. 9. Considering the fact that I had sued the Tipton County Judge Joseph Walker III, DA Mike Dunavant, and Chief Deputy Donna Turner, former FBI agent, in 2009 for judicial misconduct and official oppression in the U.S. District Court for falsely charging and jailing me to stop my lawsuit challenging a rigged election in 2006, and for my presenting to the grand jury crimes committed against me and my family, including being shot at 29 times, and our pet wolf hybrid Brandy shot and killed by a friend of the county executive I was suing over the election, and considering a Tipton County judge offered an inmate an early release from jail if he would kill me in 2016, whereby I was attacked and transported to the hospital with multiple broken ribs, cuts and bruises, is it any wonder why in 2017 I would be targeted by the FBI, who refused to investigate DA District Attorney Dunavant's conspiracy to falsely charge me with crimes he knew I did not commit in 2009? Even with an audio recording of the District Public Defender advising me of the conspiracy? And is it any wonder why Ms. Parsons is being framed by an FBI entrapment scheme, even though she has violated no law and no mens rea exists for the charge? This is a case of political retribution for exposing a rigged election and asking the grand jury to hold those responsible for terrorizing my family accountable. And it is a case of agents of the United States government conspiring with former Tipton County Chief Deputy Donna Turner, judges of Tipton County, and now U.S. Attorney D. Michael Dunavant, the former Tipton County DA who represents the United States government in this matter against Ms. Parsons, to violate our rights and kidnap us. 18 U.S.C. 241 and 242. Number 10. Then, several weeks later, Ms. Parsons was advised not of an indictment by a grand jury, but an information complaint from the U.S. Attorney that she was being falsely accused of aiding and abetting to commit conspiracy to kidnap a judge and a sheriff. The U.S. Attorney told Ms. Parsons that if she would agree to plead guilty, she could go home and feed her animals right then. Then sentencing would not be until December, and that she would not have to turn herself in to prison if sentenced until February, and she would not have to post bond. However, if she did not agree to plead guilty, she would immediately be put into prison with no bond. 11. A plea which is involuntary, coerced, unfairly obtained, or given through ignorance, fear, or inadvertence is not voluntary, and its acceptance by court would be a violation of due process. USCA 14 Rigby Russell 1968. A guilty plea induced by promises or threats or other coercion is not voluntary and is a nullity, and conviction based on such involuntary plea of guilt is void. Where plea is entered without having been informed of elements of crime is invalid. 12. In this matter, this court failed to determine the plea is made voluntarily with understanding of the nature of the charge or cause. Ms. Parsons had been told if she pled not guilty, she would be put into prison immediately and not released on bond, which is in violation of the 8th Amendment, providing for no excessive bail shall not be required, and had the U.S. Attorney actually thought she was guilty, he never would have released her, let alone without a bond or condition. To Ms. Parsons, pleading not guilty meant the death of her animals that depended on her daily for food and water. 13. In this matter, prior to sentencing, her attorney knew her husband is an ambassador of another country, but he sat on that information and failed to disclose it to the court, thereby concealing proof. Ms. Parsons has immunity and the court lacks jurisdiction. Ms. Parsons maintains diplomatic immunity that she has not waived, and her forced plea made under threat, duress, and coercion does not confer jurisdiction upon this court. In this matter, Ms. Parsons' attorney failed to ask for continuance, failed to review plaintiff's evidence prior to advising her, failed to ask Ms. Parsons what actually happened, ineffective assistance of counsel, and negligence. In this matter, at no time in court was Ms. Parsons interrogated or asked to testify. Julian versus U.S. Even with counsel, it is better to interrogate defendant. Meeks versus U.S. 298 F.2D, 5th Circuit, 1962. The court failed to satisfy itself that there is a factual basis for the plea before entering judgment. Where defendant pleads guilty, the court should satisfy itself by inquiry of the defendant that the conduct which the defendant admits constitutes the offense charged in the indictment or information, which the defendant has pled guilty. Such inquiry should be, example, protect a defendant who is in the position of pleading voluntarily with an understanding of the nature of the charge, but without realizing that his conduct does not actually fall within the charge. For a similar requirement, see Michigan Stat and then a bunch of numbers. Did the court ask Ms. Parsons if she understood the nature of the crime? No. Ms. Parsons cannot even define what the term nature of the crime is. If you can't define it, you can't understand it. Did the court explain the elements of the offense to Ms. Parsons? No. Therefore, it's void. Did the court tell Ms. Parsons the minimum and maximum penalty provided by law before the plea? No. Therefore, it's defective. Did the court advise Ms. Parsons of possible lesser included offenses? No. Did the court advise Ms. Parsons she was waiving her constitutional rights? No. Ms. Parsons' plea was not voluntary or knowingly, but under direct threat to her babies as she saw it. The court was without authority via the separation of power constraint on any U.S. court via the Vienna Convention on Diplomatic Relations, Article 31. Any laws enacted in contravention of constitutional principles of federalism are void. Information like indictment must charge every element of charge in order that accused and court may know exact offense intended to be charged and record be sufficient to support plea of formal acquittal or conviction. A bunch of numbers. To be adequate, information must inform defendant of nature of offense of which he is charged. A bunch of numbers. Validity of information must be tested by what is charged, not by what might have charged. He's giving case law and he's citing case law, and you can go to the actual document on Year of Jubilee if you care to look at that. It's very difficult for me to read all these numbers as I'm reading the letter. Number 16. Rule 7A1, felony. An offense must be prosecuted by an indictment if it is punishable. B, by imprisonment for more than 1 year. Waiving indictment. An offense punishable by imprisonment for more than 1 year may be prosecuted by information if the defendant in open court and after being advised of the nature of the charge and of the defendant's rights waives prosecution by indictment. Did the court ask Ms. Parsons if she wished to waive indictment in open court after being advised of the nature of the charge and of her rights? No. Citation error. If the defendant was misled and thereby prejudiced, is grounds to reverse conviction. Ms. Parsons was misled by prosecutor and by her attorney, and as such, she was prejudiced. Rule 11. Governing pleas in federal courts now makes clear that the sentencing judge must develop on the record the factual basis for the plea, as for example by having the accused describe the conduct that gave rise to the charge. Did the court give Ms. Parsons an opportunity to tell the court what she did to determine if there was any factual basis for the plea? No. 17. In this matter, Ms. Parsons' actual innocence was ignored by her attorney, who was not just ineffective, but a case can be made for criminal negligence for refusing to provide the court with my letter prior to sentencing, disclosing that she has diplomatic immunity and that she wished to withdraw her plea. And a case can be made for prosecutorial misconduct for threatening Ms. Parsons with the death of her animals, which are our family, if she refused to agree to plead guilty. And a case of conspiracy can be made between the FBI, whose false report and entrapment of an innocent lady is criminal and politically motivated. The FBI report claiming she gave their UCE a motorcycle is completely false. See photo of motorcycle taken in September 2017. 18. In this matter, I submitted a letter already filed with the court which would be considered new evidence, not available to the court prior to sentencing, but which clearly indicates Ms. Parsons' diplomatic immunity renders this court judgment and sentencing orders void, whereas this court lacks jurisdiction, is without authority, and its judgment and orders in the matter are nullities. Under federal law, which is applicable to all states, U.S. Supreme Court stated that if a court is without authority, its judgments and orders are regarded as nullities. They are not voidable, but are void, and form no bar to a recovery sought, even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. Case law cited. 20. Black's Law Dictionary, 6th edition, page 1574, void judgment. One which has no legal force or effect, invalidity of which may be asserted by any persons whose rights are affected at any time and at any place, directly or collaterally. One which from its inception and is and forever continues to be absolutely null, without legal efficacy, ineffectual to bind parties or support of right, of no legal force and effect whatsoever, and incapable of confirmation, ratification, or enforcement in any manner or to any degree. Judgment is a void judgment. If court that rendered judgment lacked jurisdiction of subject matter or of the parties, or acted in a manner inconsistent with due process. Case law cited. 21. Void judgment is one which has no legal force or effect whatever. It is an absolute nullity. Its invalidity may be asserted by any person whose rights are affected at any time, at any place, and it needed not be attacked directly, but may be attacked collaterally, whenever and wherever it is interposed. Case law cited. 22. Judgment entered where court lacked either subject matter or personal jurisdiction, or that were otherwise entered in violation of due process law, must be set aside. Case law cited. 23. Subject matter jurisdictional failings, fraud upon the court in related village of Willowbrook 37. Case law cited. Fraud committed in the procurement of jurisdiction, Fredman Brothers. Case law cited. Unlawful activity of a judge, Code of Judicial Conduct. A judge does not follow statutory procedure. Case law cited. 24. Upon reviewing the FBI reports, it is clear they are engaging in a scheme to entrap those who assert true American values of living independent, self-sufficient, and self-governing. The foundation of the American Republic is based upon these values. However, the FBI have concocted a scheme of demonizing those who are not dependent upon the governmental agencies they support. Like the term conspiracy theorist used in the 1960s on truth tellers relating to the assassination of President Kennedy, today they refer to those critical of corporations posing as government as sovereign citizens. Clearly, they are ignorant of the definition of the word sovereign, which means creator, or they assume the public are too lazy to look it up. A reference in the FBI report states, a Mr. Anthony Todd Weverka told the OMUCE that he, Weverka, believes that Parsons is a victim of the criminal justice system. Weverka was also charged by the FBI, but in his case, he was indicted with identical techniques by the FBI of asking for the location and a photo of where a sheriff lived. He provided the information. Miss Parsons did not. In this case, he was allowed to remain free pending trial and ultimately given diversion of 18 months. The court sentenced Miss Parsons to prison for 60 months. This totally disproportionate penalty would shock the conscience of the public, and any reviewing of court aware of the FBI's tactics and disproportionate treatment of Miss Parsons clearly indicates prejudice and official oppression. Furthermore, the FBI report falsely claims petitioner has a felony conviction and removed an ankle monitor and fled to evade trial. On December the 2nd, 2015, petitioner was exonerated, and the false convictions of 2009 of Tipton County were overturned by the Court of Tilshikotan. Under International War Crimes Act, Section 12, Subsection 1, all U.S. courts should recognize a pardon of another country's governmental authority. By definition, FBI are state terrorists, responsible for killing Americans at Ruby Ridge, Waco, and unarmed protester in Oregon, and now framing us. This court shall take judicial notice of these undisputed facts and offer of proof. 1. On January 1st, 2016, petitioner Michael Parsons was appointed ambassador of the Tilshikotan Nation, country of Chilcotin by hereditary Grand Chief Stanley Stump Sr. Petitioner is a Tilshikotan Nation tribal member and member of the Chilcotin Nation Congress in the country of Chilcotin. Petitioner is not a U.S. citizen. See attached letter dated April 24, 2017 by hereditary Grand Chief Stanley Stump Sr. 2. This court shall take judicial notice that the Tilshikotan Nation is recognized as a sovereign First Nation having the right to govern their own affairs, develop their natural resources, etc. Case law cited. 3. That as a signature of the Montevideo Convention on Rights and Duties of States, December 22, 1933, the United States of America is bound to the agreement that Article 3, the political existence of the state is independent of recognition by other states, even before recognition. The state has a right to defend its integrity and independence, to provide for its conservation and prosperity, and consequently to organize itself as it sees fit, to legislate upon its interest, administer its services, and to define the jurisdiction and competence of its courts. The existence of these rights has no other limitation than the exercise of rights of other states according to the international law. Article 4. States are judicially equal, enjoy the same rights, and have equal capacity in their existence. The rights of each one do not depend upon the power which it possesses to assure its exercise, but upon the simple fact of its existence as a person under international law. Article 5. The fundamental rights of states are not susceptible of being affected in any manner whatsoever. Article 6. The recognition of a state merely signifies that the state which recognizes it accepts the personality of the other with all the other rights and duties determined by international law. Recognition is unconditional and irrevocable. Article 7. The recognition of a state may be express or tacit. The latter results from any act which implies the intention of recognizing the new state. Article 8. No state has the right to intervene in the internal or external affairs of another. 4. That the delegation of the United States of America in signing this agreement expressed, the United States government is as much opposed as any other government to interference to freedom, the sovereignty, or other internal affairs or processes of the government of other nations. Clearly, this egalitarian principles that all people are equal and should have the same rights and opportunities enshrined in these articles, this delegation's expression as evidenced in the Constitution for the United States of America are the one would expect to be demonstrated clearly. The FBI does not. Will this court? 5. That as signature of the Vienna Convention on Diplomatic Relations, April the 18th, 1963, entered into force on April the 24th, 1964, United Nations Treaty Series, Volume 500, page 95, the United States of America is bound to the agreement that Article 29, the person of the diplomatic agent shall be inviolable. Inviolable. He shall not be liable to any form of arrest or detention. The receiving state shall treat him with due respect and shall take the appropriate steps to prevent any attack on his person, freedom, or dignity. Article 30. The private residence of a diplomatic agent shall enjoy the same inviolability and protection as the premises of the mission, his papers, correspondence, and except as provided in paragraph 3 of Article 31, his property shall likewise enjoy inviolability. Article 31. 1. A diplomatic agent shall enjoy immunity from the criminal jurisdiction of the receiving state. He shall also enjoy immunity from its civil and administrative jurisdiction. 2. A diplomatic agent is not obliged to give evidence as a witness. 3. No measure of execution may be taken in respect of a diplomatic agent. Article 37. The members of the family of a diplomatic agent forming part of his household shall enjoy the privileges and immunities specified in Article 29 through 36. Article 39. 1. Every person entitled to privileges and immunities shall enjoy them from the moment when his appointment is noticed to the Ministry for Foreign Affairs or such other ministry as may be agreed. Immunity is not based on recognition of, but by notification to the U.S. Department of State. 6. That notification of petitioner's appointment served upon Secretary of State John Kerry in January 2016 and subsequent confirmation of petitioner's A1 diplomatic visa from the United States Department of State, confirmation number AA006NW076 on January 19, 2017, is notification to the Ministry of Foreign Affairs in the United States. See attached official confirmation for A1 diplomatic visa from the United States Department of State. That United States Code 28, Section 1330 states, ambassadors are immune from prosecution in any U.S. court. 8. The Constitution for the United States of America, Republic states, in all cases affecting ambassadors, the Supreme Court shall have original jurisdiction. All treaties made or which shall be made under authority of the United States shall be the supreme law of the land, and judges in every state shall be bound thereby, and judicial officers of the several states shall be bound by oath or affirmation to support the Constitution. Whereas Miss Parsons is my wife, this case affects petitioner and ambassador. 9. Whereas the attorney in collusion with the FBI have deprived me, my wife, and my family, and the people of the sovereign country of Chilcotin of my life, liberty, happiness, property, and work, they are in violation of Title 18 U.S.C. 1201A. Whoever unlawfully seizes, confines, kidnaps, abducts, or carries away and holds any person when the person is a foreign official, as those terms are defined in 1116B of this title, for the purpose Purposes of this section. Family includes spouse and parents. Foreign government means the government of a foreign country, irrespective of recognition by the United States. Foreign official means ambassador of a foreign government or any person who has previously served in such a capacity and any member of his family while in the United States. And 4b, any other representative of a foreign government who at the time and place concerned is entitled pursuant to the international law to special protection against attack upon his person, freedom or dignity, and any member of his family then forming part of his household under 18 U.S.C. 1117 if two or more persons conspire to violate section 1116 of this title and one or more persons do any overt acts to affect the object of the conspiracy, each shall be punished by imprisonment for any term of years or for life. In this case, the controlling statute, 18 U.S.C. 1201, kidnapping A4, defines the person is a foreign official and internationally protected person as defined in section 1116b of this title, and section 1116b2 defines that a foreign government means the government of a foreign country, irrespective of recognition by the United States. Clearly, this is undisputable proof that no recognition by the Secretary of State is required. Conclusion. 1. The United States District Court's judgment and sentencing violates the Constitution and laws of the United States treaties and international law. 2. The United States District Court lacked jurisdiction to enter the judgment. 3. The judgment or sentence is otherwise subject to collateral attack or review. Although a plea of guilty may not be withdrawn after sentencing, the plea may be set aside on direct appeal or collateral attack. Federal Rule Criminal Procedure 11DE. Therefore, upon a motion to vacate and set aside sentencing, and if court finds that the judgment was rendered without jurisdiction or otherwise to collateral attack, that there has been such denial or infringement of the constitutional rights of a prisoner as to rendering the judgment vulnerable to collateral attack, the court shall vacate and set aside the judgment and shall discharge the prisoner or grant new trial. 28 U.S.C. 2255. The matter is a clear case of entrapment by the FBI, prosecutorial vindictiveness, and outright extortion by the prosecutor, ineffective and negligence of counsel, and evidence that shall be considered new to the court given the fact that Ms. Parsons' counsel refused and or failed to submit it to the court, and structural errors by the court denied Ms. Parsons the right to know the true nature and cause whereby her actions or lack thereof does not actually fall within the charge, whereby interrogation by the court would have reversed its course of action and dismissed the matter. For these reasons, this matter shall be dismissed, vacated, set aside as it pertains to this court's order of sentencing, and an immediate stay of the report date specified by the U.S. Marshals on February the 20th, 2018, respectfully submitted under duress without prejudice as a matter of right. Certificate of service as a matter of right by special appearance only. Petitioner Ambassador Michael Parsons of the sovereign Tilshikotan Nation, country of the Chilcotin, hereby certify the following is true and correct to the best of my knowledge, addressed to the Honorable Judge Lippman, care of Clerk of the U.S. District Court, 167 South Main Street, Memphis, Tennessee, 38103, and per federal rules is deemed filed today, February 15th, 2018, under duress without prejudice. Signed by Ambassador Michael Parsons, Tilshikotan in Nation, country of Chilcotin. This document has been uploaded to the Year of Jubilee page for Michael Parsons, Pat Parsons, and Sue Holland. Just look for 11-page petition to Judge Lippman.